Hi, my name is Charmaine Edusma Bigkas, third year college student under OLC A333 A037. This subject is criminal procedure and court testimony. I will answer 7 questions for today. Number 1. How court acquires jurisdiction over the person of the accused? Define each. By voluntary submission, bail, and by arrest of the accused. By voluntary submission, the accused recognizes the jurisdiction of the court over his person and will abide by the orders and directives of the court until the final disposition of the case. Bail is the security given for the release of a person in custody of law, furnished by him or a bondsman to guarantee his appearance before any court as required under conditions hereinafter specified. Bail may be given in the form of corporate surety, property bond, cash deposit, or recognizance. Number 2. What are the forms or kinds of bail? Define each. Cash bail, corporate surety, recognizance, and property bond. Cash bail is a sum of money in the amount designated in an order fixing bail, posted by the accused or by another person in his behalf with the court or other authorized public officers upon conditions that such money shall be forfeited if the accused does not comply with the directives of the court requiring his attendance at the criminal action or proceeding involved and does not otherwise render himself amenable to the orders and processes of the court. Corporate surety issued by a professional bondsman, that was one who habitually engaged in the business of furnishing bonds in civil actions or for persons arrested or detained for prosecution. Recognizance is the contract between the sureties and the states for the production of the principal at the required time. It is an obligation for record entered into before some courts or magistrates duly authorized to take it, with the conditions to do some particular act. The most usual conditions in criminal cases being the appearance of the accused for trial. The signature of the accused is not required as an indispensable condition for the validity of the undertaking under recognizance, except perhaps when he himself is a recognizer. Property bond is an undertaking constituted as alien on the real property given as security of the amount of bail. Number 3. When bail is a matter of right. First, before or after conviction by the Metropolitan Trial Court, Municipal Trial Court, Municipal Trial Court in cities, or Municipal Circuit Trial Court. Second, before the conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment. Number 4. When bail is a matter of discretion. Upon conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment, the admission to bail is discretionary. The application for bail may be filed and acted upon by the trial court despite the filing of a notice of appeal, provided it has not transmitted the original record to the appellate court. However, if a decision of the trial court convincing the accused changed the nature of the offense from non-bailable to bailable, the application for bail may be filed with and resolved by the appellate court. Number 5. What are the places where bail may be filed? First, bail is the amount fixed may be filed with the court where the case is pending or in the absence or unavailability of the judge, otherwise with any regional trial judge, metropolitan trial judge, municipal trial judge, or municipal circuit trial judge in the province, city, or municipality other than where the case is pending. Bail may also applied Bail may also apply in any regional trial court of said place, of if no judge otherwise is available, with any metropolitan trial judge, municipal trial judge, or municipal circuit trial judge therein. Second, where the grant of bail is a matter of discretion, or the accused seeks to be released on recognizance, the application may be filed in the court where the case is pending, whether on preliminary investigation, trial, or appeal. Any person in custody who are not yet charged in the court may apply for bail with any court in the province, city, or municipality where he is held. Number 6. When warrant of arrest is issued by regional trial court, within 10 days from the filing of the complaint or information, the judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. He may immediately dismiss the case if the evidence on record clearly fails to establish a probable cause. If he finds a probable cause, he issue a warrant of arrest or commitment order if the accused is already been arrested pursuant to the warrant issued by the judge who conducted the preliminary investigation, or when the preliminary or when the complaint or information was filed pursuant to section 1 of this rule. In case of doubt on the existence of probable cause, the judge may order the prosecutor to present additional evidence within 5 days from notice, and the issue must be resolved by the court within 30 days from the filing of the complaint and information. By municipal trial court, when required pursuant to the second paragraph of section of this rule, the preliminary investigation of cases falling under the original jurisdiction of the Metropolitan Trial Court, Municipal Trial Court, or Municipal Circuit Trial Court may be conducted by either the judge or the prosecutor. The procedure of the issuance of the warrant of arrest of the judge shall governed by the paragraph A of this section. When the investigation is conducted by the judge himself, he shall follow the procedure provided in section 3 of this rule. If his findings and recommendations is affirmed by the provincial or city prosecutor or by the ombudsman or his deputy, and corresponding evidence is filed, he may issue a warrant of arrest. However, without waiting for the conclusion of the investigation, the judge may issue a warrant of arrest if he finds after an examination in writing and under oath of the complainant and his witnesses in the form of searching question and answer that a probable cause exists and that there is a necessity of placing the respondent under immediate custody in order not to frustrate the ends of justice. When warrant of arrest not necessary, a warrant of arrest shall not issue if the accused is already under detention pursuant to a warrant issued by the Metropolitan Trial Court in accordance with paragraph B of this section, or if the complaint or information was filed pursuant to the section 7 of this rule, or is for an offense penalized by fine only. The court shall proceed them in the exercise of its original jurisdiction. Number 7. What are the remedies after the court acquires jurisdiction? Number 1. Quashal of information. Number 2. Assailing the validity or legality of the warrant of arrest issued against him. Number 3. Assailing or questioning the regularity or absence of preliminary investigation. Number 4. Quashal of the search warrant, suppression of evidence obtained, and or number 5. Suspension of proceeding by reason of the prejudicial question. Number 6. Motion for bill of particulars. Number 7. Motion for production and inspection for material evidence in possession of prosecution. That's all. Thank you.